Well, welcome to our session this evening with regard to planning for persons with disabilities and elder law issues. This is obviously an issue of interest and importance. We've had a lot of inquiries in our office about this seminar, and we create literally hundreds of these trusts over the course of a year. They have become, special needs trusts have become a very, very important tool in the toolbox of an estate planner and of anyone who has to address the needs of an individual that has a disability. In fact, in some states, lawyers are now being disciplined for not doing special needs trusts when they're called for. So it's something that where a family member has a disability, it's really absolutely imperative to at least evaluate it, to determine whether it's the right idea, and to thoroughly investigate that issue. The legal landscape for dealing with disability issues is different whether you are under 65 or over 65. When you are under 65, you can create a special needs trust with a disabled person's own money. But if you are over 65, then you have to look at a separate set of issues which are called elder law planning, and we have this evening at the third of our presentation will be by Drew Coates and Ann Coates. Drew is finishing up many years of service at the Department of Public Welfare, and Ann Coates is an attorney in private practice who deals with these elder law issues in terms of techniques that can be undertaken to qualify for medical assistance, to obtain public payments for nursing home services. But there are a lot of issues really that one has to consider when an individual is disabled and is a member of a family and is part of the whole planning system. It's not just a special needs trust. It's not just planning for entry into a nursing home. It involves really the whole of the person, and I think it's very important to look at these issues, not to sound too mystical, but holistically. You do have to look at the entire needs of the individual with disabilities and the family and the financial circumstances that surround it. It's a reason is really unable to earn a living, whether it's because barely a snap judgment as to how to address the needs of an individual who, for whatever of disability or age or whatever the situation. So when we look at these issues, we think of a number of factors that we have to look at. Typically, wills, perhaps for the disabled person or the persons who care about that individual, have to be evaluated. And there are a variety of mechanisms that can be placed into the wills, including tax planning trusts, and in our earlier seminars we discussed things like credit shelter trusts, disclaimer trusts, spendthrift trusts, minors trusts, and those discussions are going to be available on our website in the very near future. So if you weren't there, you'll be able to look at them. But for tonight's purposes, I'd simply point out that there are tax planning mechanisms available in wills, so that the federal estate tax, which begins after about a $2 million point in gross estates and is typically at a rate of about 45%, so that can be avoided in many, many circumstances. And it's important to remember that insurance, life insurance, is part of the gross estate for federal estate tax purposes. So you may think, oh, I don't have anywhere near $2 million, but you do have to consider your retirement plan, your life insurance, the value of your home. All of those things have to be factored in. And obviously, if there are minors or persons with disabilities or incapacities, specialized trusts have to be used in order to, if they're going to be taking under the estate, in order to manage it, to make sure that they don't spend the money unwisely, or that people take advantage of them, or that they lose public benefits. And we will talk about the use of special needs trusts in great detail in just a few minutes. Powers of attorney and advanced medical directives. These have to be entered into by someone with legal capacity. Only a person with legal capacity can create a power of attorney giving another individual authority to act for them financially or medically. Many times people come to us on behalf of individuals with disabilities with the question, they can sign their name, can't we just do a power of attorney? Well, the answer really depends on that level of capacity. Does that individual, whether they are disabled cognitively because of mental retardation, mental illness, or whether they're disabled cognitively because of Alzheimer's or old age, the question is always, do they have the capacity to understand what they're doing and to make a reasoned judgment as to what they are doing? So these have to be entered into. Powers of attorney and advanced medical directives can only be entered into while an individual has legal capacity, has competency, is able to understand what they're doing. And in some circumstances where an older family member is beginning to lose capacity, is beginning to have a noticeable loss of cognitive ability, you really want to consider these issues sooner rather than later, because they can enter into, so long as they have remaining that capacity to understand the nature and quality of what they're doing, and once it's too late, it's usually too late completely. So, and by doing especially a power of attorney, you can avoid the necessity to undertake a guardianship. Guardianship is available for any individual who, because of mental infirmity, is unable to make and communicate responsible decisions concerning their personal affairs, concerning their financial affairs. And when guardianship is ordered, it's separated into guardian of the person and guardian of the estate. In order to have a guardianship, the person must be adjudicated incapacitated because of that mental disability. And it doesn't matter whether they are young or old. 18 is the starting point at which you do a guardianship for an individual, but it can extend to any age. The relationship, though, between powers of attorney and guardianship, in most circumstances, a power of attorney, if it can be entered into by an individual who has mental capacity, is very useful because it is far easier to do, far less cumbersome, does not require judicial intervention. Guardianship proceedings are while they are not technically difficult, there are a lot of hoops to jump through. You have to get a physician's affidavit, you have to serve all the next of kin, you have to file a judicial petition, get a court hearing, serve the disabled individual, and frankly on and on. It is a cumbersome proceeding that takes time, and the last thing you want to have to do, if you can help it, is have to do a guardianship in an emergency situation where someone needs medical care and the hospital is refusing to undertake exploratory surgery, or surgery which is not non-emergency in nature, or they want someone to sign off on any form of treatment. So power of attorney and advanced medical directives are certainly more desirable than pursuing a court process to obtain guardianship. Advanced medical directives only kick in, by the way, when, and this is Pennsylvania, they only kick in when you are really close to death. Under Pennsylvania law, your statement in an advanced medical directive of what you want only is to be followed when you are in an end-stage medical condition, meaning you are about to die, and further treatment will only prolong the process of death, or where you're permanently unconscious. And in either case, the attending physician has to certify in writing that you either are at an end-stage medical condition and can't communicate, or that you are permanently unconscious and won't wake up. Those are the two circumstances where advanced medical directives, where you state in advance the medical conditions that, or the medical processes that you want used at your end of life, are to be considered. So the power of attorney can deal with financial, medical, personal decisions really at any time. And what we call a durable power of attorney is one that lasts after you become incapacitated. An advanced medical directive is oftentimes called a living will. In fact, Pennsylvania law now actually refers to them as living wills. The clearer technical term really is an advanced medical directive. That is a statement of what you want when you are about to die. And hospitals under Pennsylvania law should follow that where you have provided those instructions while competent. Long-term care insurances. There are a variety of policies that are offered by many large companies which provide financial benefits when you are in need of long-term care, typically nursing home or the type of skilled nursing services that might be able to be imported into the home. What I will say about long-term care is that it is extremely important, if you are considering it, that you get a variety of quotes and make sure that you are comparing apples to apples and oranges to oranges. There are a lot of different companies that have a lot of different plans that can differ dramatically in terms of when they pay, how much they pay, how long they pay. All of those things have to be considered very carefully before you make the purchase of long-term care, because you want to make sure that you're getting the best benefit you can. Obviously, the younger you are, the less expensive it will be over the time period of the insurance. You also want to make absolutely certain that you know what the premiums will be for however long it is. And there have been a number of articles written recently that individuals are purchasing long-term care thinking they have a locked-in rate for life when in fact they don't. That there is some language in the long-term care contract that allows the company to change the rates if market conditions meet certain standards. So it's very important to know what you're purchasing if you're going to purchase that type of insurance, which is usually bought either to help with nursing home costs or to assist in providing services in the home so an individual can spend their last days at home. And then the final topic, as I say, that Drew and Ann Coates will talk about is Medicaid planning for persons over 65.